Kia ora. I'm speaking with Peter Cranney, who's an associate at Oakley Moran and a well-known employment lawyer, about the recent Employment Relations Amendment Bill that's been tabled before the House. And I'm going to ask him some questions about the significance of this bill, because there are some wide-ranging and wide-reaching changes that it proposes to our existing employment law system. So first of all, Peter, I want to ask you about remedies. Can you comment on what's being changed with these proposed amendments?
Now, this particular branch of the alterations, shall I call them, really is designed to limit and reduce workers' rights in relation to unjustified dismissal and other types of personal grievance. The current law allows the court or the authority to reduce remedies if the actions of the employee so require. So if certain misconduct is associated with a dismissal by the employee, their remedies can be reduced. This latest bill has greatly changed that. First of all, they've said that if there is any misconduct, any contributing behaviour by the employee to a dismissal of any kind, then the remedy of reinstatement is not available to the employee, and also the remedy of compensation for humiliation and distress and other benefits of a monetary kind are not available either. There is no equivalent provision in the statute which punishes an employer who engages in misconduct.
Another aspect of the bill, Peter, is the so-called income threshold, which effectively makes it impossible for a worker who earns above or at a certain specified income to raise a personal grievance for unjustifiable dismissal. Do you have any comments on this threshold and its effect?
The surprising thing is that nobody was really asking for anything like this. It is true that there are occasionally personal grievances from people who are at 180,000 or 200,000, but they're quite rare, and there has been no demand by any groups to abolish employment rights for those people. The danger in doing it is that one of the aspects of New Zealand which makes this country attractive to senior doctors, to very senior computer people, and to other senior professional groups and so on, is that they see this up to this point as a place where it's difficult to unfairly dismiss. This is sending the wrong message from a country that's trying to encourage people to come and work in our health system, our universities, our education system.
Where does that leave the personal grievance system as a whole?
I think striding towards being dismantled. These kind of changes are not going to assist anybody at all, I don't think.
So there are some other changes that are also being introduced by this bill. Notably, there's quite a significant change or addition to Section 6 of the Act, which essentially enshrines that the test for determining a worker's status, whether they're an employee who's entitled to all the protections and benefits that come with being an employee, apply, or whether they're an independent contractor, will depend on the real nature of their work.
At the moment, the issue about whether someone is an employee or not is determined by the court or the authority, and the test they apply is what is the real nature of the relationship between the employee seeking a declaration and the person the employee is saying is their employer. That's an important question because if you are in the definition as an employee, you are given access under New Zealand law to very important human rights. Annual holidays, public holidays, sick pay, parental leave, and all kinds of other employment protection provisions. And so it's in the interests of some groups, obviously, to try to water down the definition of employee or to avoid it completely.
And I think that's the thing, the real problem before us is misclassification of workers to avoid giving them their rights as employees.
Yes.
And that's not being addressed with this.
No, it's going in the wrong direction.
So there's also a change to the test of justification, which talks about whether an employer was obstructed by an employee in carrying out their process or employment process. Can you comment on what that means?
Well, I think I know the origins of it. At the moment, under Section 103, capital A3, there are 3 or 4 steps which a fair and reasonable employer must do. And they're quite good steps as it currently stands. They require the employer to be fair, decent, reasonable, thorough, to hear with an open mind. Now, this amendment is introducing a new phenomena into the statute, which is that the employer is going to try to prevent the employer from being fair and reasonable. It's really a bit of an employer fantasy, this one. What happens in these disputes is employers pretend to be fair and reasonable. You're really pretending to have a fair meeting while you've already written out a dismissal letter. That's the sort of thing this is going to open up, is those kind of arguments. The underlying thinking behind the forces behind this section are that they want to use that subsection to pressure workers to accept unfair processes,
Right.
and use that as a basis to uphold the dismissal.
Right.
I hope I'm not sounding too cynical.
Is there anything else you want to say around these proposed changes?
Well, all I would say is it's not the last of it. We have suffered very significant backward steps in legal rights in the country over a very short period of a couple of months. It'll make it easier to dismiss. It'll make people less secure. It'll increase the power of the employer over the employee in the workplace, and that's not going to be the last of it.